guys, good morning, or at least where I'm at, it's early morning and probably earlier in other places. So we're going to take a look at the plaintiff's response in the Maya Kowalski case to the motion for new trial based on juror misconduct that the defense brought up. As you know, that stirred up a lot of controversy because the primary evidence that the defense had were the comments of juror number one's wife on social media, and that brought up allegations. Is this misogynistic? What is this about? And all that. Well, of course, she's free to say things that she wants to say. She's not on the jury, so she can talk. And after the trial is over, he can talk. And the whole thing is whether they were talking together in some way that prejudiced this case. And the plaintiff has something to say to that. And guess what? They don't agree. So let's take a look at it, because I think they do a pretty great job in this document. I did scan through it here. Hello to Durham. How about that? Yeah, winter is here, and I see it's slightly freezing and going to be more freezing tonight. So if you have a spigot outside, get that thing covered up soon, because we get cold easily here in the South. We're not the hardy Viking stock, or at least not some of us. Some, I should speak for myself. There are people, of course, from Northern Europe. Plenty of those in North Carolina, as the Scots settled it substantially. Something we've been reading about lately. All right, let's get into this motion. Sorry, I haven't had coffee yet. All right, they start out strong here, the plaintiff's lawyer. That's what I was trying to convey in the thumbnail about this case, saying that the motion should really be entitled Juror Misconduct by Proxy and should be denied in its entirety. And of course, this case was the premise by the plaintiff is that the hospital had a false Munchausen by proxy. So good call back there by the plaintiff's attorney. And really, it is kind of true, right? They're trying to say that if you read what the juror's wife wrote, then they were talking about things, and so they have to throw this verdict out. And not all the things, of course, even indicated potentially they were talking together. Some of them just expressions of her own opinion that couldn't possibly be construed against the plaintiff's sides, or at least attributable to juror number one. Sorry, I'm reading about where people are from, because I always like to do that. 22 degrees in Arkansas. I guess that's what's coming here, huh? Because it's going to get down into the 20s tonight. So it's flowing east, and here we go. And we'll say this for Durham is they've made a transition to having some great breweries in that town, that's for sure, as North Carolina moved away from its tobacco-centric economy. And yes, very good point. Winston-Salem here, a lot of Germans there. And of course, assuming you do mean Winston-Salem from that, I just mentioned tobacco. The brands Winston and Salem, and of course R.J. Reynolds of Winston-Salem. So, yeah, a lot of the leaf in this state. All right, let's carry on here. So the first thing they do is, we talked a little bit kind of last night, is you get technical arguments and merit arguments, and this is more on the technical side. Hey, they failed to preserve the challenge, so whether there's any merit to it or not, they've essentially waived it, or they're too late to bring this. So let's take a look here. A couple of people checking in from Texas and Florida. Yeah, Robert the Bruce, baby. We're checking into it. And it is very cold in Denmark, -2 Celsius, which even I know is below freezing. All right, so they're saying that the defense relies on information that's pre-verdict that it appears known to the defendant before the verdict. Now, this isn't a strong argument in and of itself, because it has it appears in it, which is one of the things the plaintiff takes issue against the defense motion, saying that all you're doing is saying it appears that the wife and the husband talked about the case. You don't actually have anything to show that. So when you see it appears, you're not dealing with the strongest argument. That's okay. You got to make the technical argument, and they're going to do it more than once here for more than one reason. But really, I think this motion comes down to the merits, which is, are the instances cited by the defense really something that would cause the judge to go, well, they must have been talking to each other? And the plaintiff, I think, makes a good case why that's not correct. All right, so they're saying the defense waited until the verdict came in before bringing the assertions to the court. And if that's true, then that is a waiver. You can't do that. You gotta bring it up when you know it. Had it acted timely, if the claims had any merit, and again, so we're talking about the technical kind of argument here, they could have been addressed before this 9-week trial went to the jury. And that's one thing I mentioned again, I won't harp on it, is a lot of times when you see motions, especially if they go up to a higher court, but this is at the trial court level, there's a technical argument that some procedural requirement wasn't met, or there's a bar or something like that, and then there's arguments on the merits. So you're usually going to see both, and they're not always of equal strength. So they mentioned that the Florida Supreme Court says, hey, this system's already overburdened. We don't have the luxury of allowing jury verdicts to unravel or be subject to attack if there's information that could have reasonably been obtained before the trial begins. And they say that logic applies to while trials in progress. That makes sense. And good morning to Oklahoma. All right. So let's get down to some of the major things here. The defense based its motion largely on internet posts during the trial, as we all know. These materials were available to the defense in real time, the plaintiff says. And that's true. If they're watching the internet, they could see it like anybody else saw it. In fact, the defense says the entire internet community knew about it, they say. And since there were members of their team and also close adjacent family members, the plaintiff says it's only fair to say then that they had access to this information as it was occurring. Why didn't they bring it up? And then they say the defense claims it strains credulity to believe juror number one and his wife were not communicating with each other, but they're wrong. And we're going to look into that. Now we're getting onto the merit side of things. The court told the jurors they were not to discuss the case with anyone, even family members. So if you engage in the unsupported assumption that the defendant posits, that would mean there could never be a married juror. The mere fact that they're married doesn't mean they talked about the case to each other. And that is certainly true too. And it's also true that the fact that the juror talked about the case after it was over doesn't mean he talked to his wife during the case. The fact that his wife talked about the case while it was in progress doesn't mean she talked to him. You need to show the evidence that that happened. And they point out that defense counsel was actively engaging with members of the public through the internet during the trial, and therefore all the pre-verdict post-defendant complaints about the motion should be considered known to the defense team before the verdict. And obviously on the merits, that's not fair, just like it's not fair to say that the juror number one knew about his wife's post, although there's more merit to this because the defense was actually looking at internet stuff. They're making the point here that if we're going to deem all this stuff known by the juror, then you certainly need to deem it known by the defense because they were definitely looking at the internet. I think that's a fair point. Let's see. And this is all too that you should have brought it up when you knew or reasonably should have known about it. So the technical side of it. And that's not without merit. The judge could find that either as the exclusive or part of the reason to deny this motion. The correct standard for juror interview is something they want to point out. We just don't haul jurors in for the heck of it because we're butthurt about how the verdict came out. There's got to be a reason, and what is it? So they said the courts note a strong public policy against allowing litigants either to harass jurors or to upset a verdict by attempting to ascertain some improper motive underlying. And if you've noticed in these cases, it's not easy to convince a judge to open up an investigation into what the juror did, especially calling them back in. An inquiry is never permissible unless the moving party has made sworn factual allegations that, if true, would require a trial court to order a new trial. And that's going to need to be something more than speculation. Otherwise, you could just file an affidavit that says, I'm sure these jurors all decided before the case was over, please call them in and ask them that. That's not supported by any evidence, right? So we've got to look at the evidence. And they say the court says that the standard is there's an inquiry only into objective acts committed by or in the presence of the jury or a juror that might have compromised the integrity. Okay. All right. So we're dialing it in a little bit. And I think that's fair. For example, my theory is if they did call this juror in, all the judge would do is say, did you ignore what I said about talking to people and lie to me when you said you didn't? Did you talk to your wife about this case or read what she wrote? It's not going to be some wide-ranging case against this juror. And somebody says they watched a trial where the judge let the spouse of a juror be in court. Well, yeah, I mean, they're a citizen. They're not under any disabling reason why they can't come to court if that's what they want to do. Now, they can't signal each other, but neither can anyone else. I mean, the fact that they're a spouse doesn't create this magical burden that they have to stay away from everything. Now, is it wise to get in the middle of it and maybe, help cause some trouble like this? Probably not, but that, that's a personal decision. It doesn't mean the law forbids it. So, all right. So the motion supports the request to interview the juror solely by inferring he's violated the court's instructions based on the conduct of his wife and others. And as we're going to look at, I don't think that inference is as strong as the defense would like it to be. And they want the court to impute the actions and statements of jurors, number one's wife and others, to him misconduct by proxy. That's definitely not going to fly. The fact that the wife was saying things on YouTube channels supporting Maya's case, you don't go and say, well, the juror number one must have been telling her to do that. No, I don't think you're allowed to just assume that. So again, you're really going to need to show that they were communicating with each other, the information flowing one way or the other in some kind of material way. Let's see. They're mentioning a case here, and I know I highlight it for a reason. Here it is. So a brother and a sister served together on a jury until the brother was an alternate, was discharged. And the trial court said, nah, that's a mistrial right there. The court said, I can make a presumption they are brother and sister, and I found out they drove back and forth together for the trial every day. They must be talking about this. And the appellate court said, no. This is a series of assumptions and inferences rather than competent record evidence. There's no evidence in the record that the brother and sister discussed the testimony or evidence with each other or otherwise violated the trial court's daily admonitions to the jury. To the contrary, they mentioned how the trial court asks these people this every day, and the court said, if you don't have some evidence against other than that. Now, is it fair to say if you're a brother and sister on a jury and you're riding together every day to it that you might talk about it? Of course, it's fair to say you might because you're in proximity to each other, but that's not the same thing as saying that's evidence that you did it. Okay, that's a big difference. It's what's possible or more likely. For example, it's more likely that juror number one discussed the case with his wife than it is me or someone living in the Arctic hinterlands because there's no proximity there. But the mere fact that they had the opportunity to talk to each other does not constitute evidence that they did. So again, we've got to look at this evidence. Somebody mentioned Fallow's lawyers tried the same thing to get an interview with a juror. Oh, because there was an interview with a juror. Yeah, I see a lot of times people are like, oh my God, the jury shouldn't talk or whatever. But that the jurors can do that. That's always been the rule. After the case is over, they can say what they thought about it. And juror number one has certainly done that, and he certainly has the right to do that. Now, again, if what he said was, I took a bribe to vote this way, then that doesn't come under you're allowed to talk about the case. You're admitting to misconduct and that. But that's not what he did. He just talked about how he felt about the case, and he's allowed to do that. A motion seeking to interview jurors is based on mere conclusory statements based on speculation and surmise that if interrogated, the jurors might have something to say that would be material to whether the court should award a new trial is insufficient. The motion for interview will fail if there's no suggestion in the record of any misconduct or irregularity on the part of any juror. And here there's really, I think, only one comment by the juror during the case that they say, okay, there's two comments and we'll hit them, that they say is improper. The rest of it is assuming that what his wife said was based on something she got from him. I certainly don't buy that. Here, juror number one's wife did not serve on the jury with her husband. There's no reason to assume juror number one, blah, blah, blah. Discussing whether merely because of his wife. She was biased in favor of the plaintiff. And, okay, yeah, she said things that if you read it, it would say she was taking Maya's side on it. I don't think that's arguable. That's her right to do that. But they're saying there's no evidence of actual misconduct by juror number one. And they cite distinguishing facts from the cases that the defense cites. The judge learned of multiple undisputed instances, objective acts, where sequestered jurors had violated the sequestration order by spending time together in a bar, having dinner with other people, watching news account of a trial, even with the sound off, and then remarking about it. Okay, that's different than this case. The plaintiff learned the undisputed fact that the jury foreman's brother was an employee of the defendant's insurance carrier. And in that case, because I remember that case, I think they admitted that they did talk to each other. And so they're saying that the appropriateness of a jury interview or further court review was based on evidence of actual misconduct in which the juror participated. Okay, so if the juror is participating in the act, then you can draw some inferences from that, certainly, but conclusions and stuff. But I see what they're saying here. The correct legal standard for a new trial. Okay, so they covered the jury interview, and now we'll look at what about this whole thing about a new trial. Defense motion says that potentially harmful juror misconduct is presumptively prejudicial. That's incomplete, the plaintiff says. There's more to it than that. In this Amazon case, the defendant argued that the undisputed evidence that jurors had violated the sequestration order placed the burden on the state to refute a presumption of prejudice raised when juror misconduct is shown. They say the Supreme Court of Florida disagreed, saying it's not the rule in Florida. It should be clearly understood that not all misconduct will vitiate a verdict, even though such conduct may be improper. And that's true. Not every remark to a juror or from a juror, even if it touches on the case, causes a verdict to be thrown out. that's silly. And the law is sometimes can be silly, but it is generally not that silly. It's generally not. It's necessary either to show that prejudice resulted or that the misconduct was of such a character as to raise the presumption of prejudice. So I saw earlier somebody made a comment and said, well, she only knew he was on this case, or how did she know he was on this case if he didn't tell her? So if that were all the communication that were alleged, the mere fact that he said, yeah, I'm on that big case, my case, I can't talk about it, would that mean this trial should be thrown out? I don't think that's the kind of thing that gets a trial thrown out. It's not an absolute black line that if one toe goes over it, then this whole trial gets thrown out. Is really not how it works. But that's not what the defense alleged, of course. They alleged there was material information being moved back and forth between the juror and his wife, and they also alleged that the juror was doing research about the case, which is also something you're not supposed to do. All right, so let's move on from that. They again talk about the objective facts and actual conversations. Yeah, that brother thing. And there's no actual conversations pointed to here. There's nothing, like the wife didn't say, I just talked to my husband about this case, and he says there'll be a lot of questions tomorrow. Or he says the jury, there's no reference to a conversation. So you cannot say that one occurred based on the evidence unless you can infer it from the content of what she was saying and what he was saying. Why is he telling her he's on a jury? A problem? What's he supposed to tell his wife? Yeah, well, of course he can tell he's on a jury. I think the question is, can he say he's on this case? And I'm going to say that even if you said you're on this case, that's really not an issue. There might be other popular cases going on with a jury in progress, and the juror could say, well, I could talk about that because I'm not on that jury. I mean, it's not every single communication between the people. It's whether it's a wife, a friend, a stranger, or whatever, is forbidden. And that's not the defense motion. They try to show that this was, in fact, prejudicial. All right, so they say the juror took the oath, same as the other jurors, to follow the instructions of the court, and that the court asked them all the time, have you talked to anybody, or that sort of thing, and no. And Florida law recognizes there's a presumption that jurors will follow their oath. So is an inference enough to, if you can draw it, to get past a presumption? Yeah, Florida says don't discuss the case with anyone. I don't see that as, if that's what they were alleging here, I don't think that would amount to anything. I mean, obviously you shouldn't talk about the case with people. I don't even know that counts as talking about the case, letting somebody know that you're on it. For example, saying, listen, I got slotted on the Maya case. Do not talk about that case while I'm around, right? Because if you don't tell your wife that that's the case you're on and she's going to watch it, she might start talking about it. And what are you supposed to do there? And if you get up and walk out of the room, you've created the inference that you've let her know that you're on the Maya case. So I hear what you're saying. I kind of disagree with that position in terms of it. While you say it's a problem, I understand what you're saying. I don't think that it's going to get any kind of motion sustained that affects the case. Like the motion, the supporting affidavit of Shapiro only contains suppositions and theorizations, and we'll look at those inferences certainly as we get further into this, into the merit part of it. And they say the extent to which the motion reaches for any purported factual basis is best demonstrated by the reference to juror number 1's post-verdict online statement. Oh, I didn't realize that was post-verdict that he said it, but I guess he's referencing back what he said during the trial. Oh boy, I'm in trouble once again. And from the once again, the defendant says the only way he would have ever said once again about being in trouble is if he knew there'd been a prior motion to have him taken off the jury. That's the only thing that could mean. And the only way he could have found that out, they say, was from his wife telling him. Well, first of all, it's not the only way he could find it out. If a lot of people knew about it, so if he did find out about it, it doesn't necessarily follow that it was from his wife. But also, I'm of the position that I'm in trouble once again does not lead to the conclusion that he's talking about a motion to have him removed from the jury, because the trouble he's talking about is I think the bailiff asked him to hold up or something like that, and maybe he had similarly abused a break time in the past. Had wandered somewhere that he's not supposed to wander or whatever like that. There's lots and lots of reasons other than I knew things that were going on in the trial and I was about to be thrown off. I considered myself in trouble for that, and now I'm in trouble once again. I think that's creating a lot out of those two words, and I do not think the judge is going to buy that. That's my position. As they say, patently, it's pure conjecture. Okay. especially if it's not referencing back to when he was on the jury, because after the case is over, he's certainly free to find out he was quote unquote in trouble by defense trying to take him off of the jury, out of the jury pool for deliberations. All right. And then they say this, which I find some merit to: the defendant contends misconduct. All the matters that defendant contends show misconduct by the juror are matters anyone watching the trial would know. Question about the creature comforts. And when I did the first stream on this, people said, hey, that actually was said during the trial. And the plaintiff's lawyer references that here. They note that defense claims that the juror number one conducted research on one or more issues, but they only cite one issue. And that is this creature comfort. And then, of course, they go to the point that it was referenced in the trial before he asked it in a question. So from that, I don't think you're going to be able to say, well, he must have gone online and researched that one specific website that mentioned creature comforts, and that's where he got his question from, if in fact that phrase came up in trial. And it's a phrase that people know anyway. Creature comfort came later after that testimony, so we covered that one. The internet had already shot that one down at the last stream we did. Post-verdict comments. And then they go through the whole thing that the judge says. You can, you have the unique privilege to not talk about it, but you also have, you can talk to anybody. You may speak to the lawyers or anyone else about the trial. You also have the right to refuse to speak to anyone. It'll be up to you whether to preserve your privacy as a juror. You may talk about this case or not talk about it. You can watch or not watch anything about it. You're discharged, baby. Do whatever you want. Again, if you take that to admit to a crime or something, that's not an excuse, but it is free clearance to talk about the case and go on as many interviews as you want. Say everything else you want. So anyway, all right. Potential disqualification addressed on November 6th, right? And that we know that that had already been talked about in court. And the judge made comments. See, I didn't see this part of it. I didn't see most of the trial. The court said, in terms of whether juror number one has to go because he was biased or whatever, I've been watching it for more than 2 months. This is the judge talking. And the judge is kind of important because the judge will be the one to decide this motion at the trial level. I mean, he's the closest juror to my physical vantage point and location. I've been watching the guy. I have not only do I not have a doubt, I don't have a reasonable doubt, but I have no doubt that this guy has not come up with any final or fixed opinion. So do you think this is the kind of judge who's going to be tempted to think, well, if you can show me his wife was on my side on the case, I'll be glad to leap from that through inferences and then decide that he was talking about this case with his wife. I'll take those inferences and decide this guy's a big liar who had an opinion during the trial and all that. I wouldn't, I don't bet on cases. If I did, I would bet that's a losing argument for the defense. Okay, they also talk about the juror questionnaire and whether the fact that he never disclosed that Deborah Salisbury, Esquire, was involved with his wife's 2007 domestic relations proceedings. And I read this, originally, and the other thing is like, they can't even say for sure what that attorney's position in that case was. But also the fact that it was somehow involved in a wife's case from 2007 on its face doesn't mean he knew her at all, right? I mean, how do you know he knew about the attorney somehow involved in a wife's case before they were married and probably, I suppose, before they were dating? I don't think they were married that long. Defense does not claim the referenced domestic relations proceeding involved juror number one. And that juror number one never disclosed this fact. As the plaintiff's attorney says, what fact? The juror questionnaire asked whether juror number one knew, whether the juror knew this attorney and not whether his wife knew her. Right. So that's the question. Spouses can and do have different professional and social contacts and have separate lives before they marry. And also there's no indication that the wife even knows who this lawyer is. The facts don't show that. So I think the plaintiff has demolished that argument in detail. Let's see. Is juror number one the only juror who has a household companion? I don't know. But that's only somewhat relevant, and in my view, only because of the proximity issue. You could be in a restaurant and talk to people about a case. You can meet strangers. You can go on the internet. You can do it however you want to do. The question is whether this guy was doing it or not. And while he may have, I'm sure was in greater proximity to his wife, therefore more opportunity to talk about things, and it's obvious she was interested in the case, that isn't evidence by itself that he talked to her about it. So that's the problem they're facing here. And they say this lawyer, Salisbury, never even testified in this case. I think that one's done. In terms of the documentary, the defense says it seems unlikely that he didn't watch it or hear about it and that sort of thing. Although I didn't really hear about it until the case kind of cranked up. So seems unlikely isn't a lot. Isn't what I would call evidence. Is that evidence that it seems unlikely? Yeah, I mean, I don't know. Even on Netflix, did they even show this guy as a Netflix subscription? Like, what's the evidence this guy watched this documentary or talked about it? I didn't. It's open to the public. Her sitting in a gallery one day isn't a problem. Yeah, she's free to do that. She could come to the trial every day if that's what she felt like doing. And so could I, and so could you. So could the guy's brother if he has one, a kid, grandparent. Anybody can come to the case. The question is whether they're signaling, talking to, or whatever, communicating back and forth to the juror. And getting back to the motion here, the plaintiff says, this is just conjecture, baby. Just conjecture. It's inflammatory and imprecise allegations against the wife. All right, so then they go to the wife's allegedly improper actions. Again, they point out the juror says, you didn't talk to anybody about this, right? And the juror's like, that's correct. Defendant launches into unsupported theories about the wife's influence over the juror's view of the case. Now, the plaintiff observes the defendant's position, which is that your spouse's knowledge should be attributed to the other. It means the defendant's arguments are unpreserved as discussed above. So in other words, if your alleged agent, your wife, or members of your team, if everything they know is attributable directly to you, then they're saying all the stuff this wife said that was known to the defense team, and this is not a properly timed motion because it's stale, which is, I think, a clever, logical position to take. And it's in my opinion that in neither case should that be presumed, of course, and I think that would be the plaintiff's case too. Well, let's see, Mrs. Southern-Law. So the wife only went to the case once, though. She was there, I think, just one day, and nobody was told that at the time in the courtroom for sure, and no indication of that. And you can sequester a jury. I don't agree that that's needed here because the only allegation of misconduct about juror number one is that a bunch of nonsense. So you are talking about taking the jurors who basically get nothing for doing this, taking them away from everybody and just jamming them up in a hotel for cases that take months. I think the system would need to change if that were to become a regular practice. That would be, you're talking about adjusting civil grievances here, and it is an injury to people to take them away from their family for months at a time. So it should be no easy thing to sequester a jury just because social media is crazy. You just need to have rules, and those rules need to be followed. And it's one reason why you don't have a one-person jury, because if in theory one person strays from the fold and does something you don't even find about it, because you can cheat if you're sequestered too. Oh, there's no way you can find out to communicate with somebody. So of course you could, is you have a jury of multiple people. So that's part of the insulation that's there for, hypothetical and potentially real violations of the rules. That's my position on it. I wouldn't want to go sit in a hotel for months for some case for somebody who was, civil case where somebody's asking for money or whatever. So I think that has to be cautiously done, and probably the system should change if that's going to happen. It probably should change anyway for people that are on juries for a long period of time. It's extremely disruptive to your life to have to be pulled away to sit on a case for months, and there may not be any alternative to it, but that doesn't mean the jurors are being treated fairly by the state when that happens. Let's see. So they note the wife's comment, the juror Leo will be asking questions. And so the only explanation is she must have talked to him and he said, I'll be asking questions. But given his background as a law enforcement officer, the court pointed out, we could have expected he was going to ask tough questions, sharp cross-examination type questions. So the judge already said that. Was the judge going over and having dinner with the juror and his wife while they're talking about this case? I don't think so. I don't think that happened. So in other words, there's another explanation to think why this type of juror might have something to say. And the court had already said on the record, 9 weeks into this trial, I can tell you without any sort of certainty. Well, that is what he said. I can tell you without any sort of certainty that juror number 1 has been testing the evidence in this case, every single witness. I don't think he asked a question today, but I think he asked a question on almost every single question that wasn't by deposition. So the court was thinking this is the kind of guy who's has been and will be regularly asking questions. It is what it is. And I'm just gonna get rid of somebody who's annoying me. All right. Now, let's see. The court went further to say, because I'm trying to read comments that are reasonable or asking reasonable questions. Yeah. Right. So, yeah, I mean, if the judge didn't want certain people in the courtroom, the judge can control a courtroom. It's just not, it's in and of itself, the wife having a position on the case, talking about the case online and coming to the trial some of the time, that's not a problem. Now, what the defense was successful there was creating a big smoke screen that everybody can debate about. But if you go down to the core of it, the question is there evidence that they talked about the case? What if she never posted online, never showed up at the trial, but they talked about the case together in material ways? That would be wrong. So this stuff that she did is only relevant if it shows they were discussing the case. Same if it's his brother, daughter, friend, cousin, enemy, whatever. Is what she said demonstrating that they talked to each other, and it just doesn't. The fact that she said this guy's probably going to ask questions, other people thought that too. The jury deliberation, they're saying the wife's comment that juror number 1 must have told her inside information was that she could have only obtained this from her husband, juror number 1, the idea that the jury was frustrated and can't reach a dollar amount. But that's what I thought when I heard about that note. I think that's what everybody thought. And the plaintiff says, I had the same observation. It was evident the jury was frustrated, as indicated by their second note. In fact, there was some concern, I think, on the plaintiff's side that, well, they like our case, but now they're mad at us because they wanted the evidence to be more available on how to calculate what the reward should be. And somebody says Shapiro's wife and kids are here some days, which is certainly true, and all of it is irrelevant because Shapiro's not on the jury, so I mean his family can be there and he can talk about the case to his wife all he wants as long as he's not violating attorney-client privilege, whereas a juror is not free to do that. But it still goes back to the principal point that people can do whatever they want. If they're not on the jury, the juror just can't be talking to these people about it. And so you got to dial it back into that. Did that comment from the wife, the comment she said, I think the note yesterday, the jury was frustrated. Did that have to come from her husband? And you know it doesn't have to come from him. You know that that's an opinion you could easily develop if you were watching the case at that point, and I think it would be one you would quickly develop. That's certainly what I thought. I wasn't talking to any juror on the case or sitting in the gallery. And they're talking about what the comment was. And they say that the wife's sentiment of the jury matched the overwhelming sentiment of social media commenters and public followers of the trial. And they show lots of comments talking about how the jury is upset. And they all weren't, there wasn't like a coliseum full of people talking to juror number 1 about the case during its deliberation. So I think the plaintiff makes the point that you cannot have an inference here that opinion could only come from inside information from juror number 1 when many, many, many people from all over the place had the same opinion. And I think that's a fair point. That's my opinion. So let's see. None of this is going to make any difference. Everybody should have their day in the sun if they want to say this is going to overthrow this verdict. Enjoy it until the judge rules on it. All right. So the juror number 1's wife's comment regarding the jury not liking a witness. The jury did not like this witness or any of the witnesses the defendant presented at trial the day prior. And the defendant ignores the most rational explanation for the comment. The juror was present in the courtroom on a day that this witness testified and can see and assess the jury members' reactions. Everybody involved in the trial, if you're in a gallery and you're interested in it, you're trying to see what the juror is buying, what this witness is selling, how they're reacting to them. The attorneys are, the paralegals are. If there's a jury consultant, that's what they're doing. Everybody's trying to develop an opinion. It was my opinion which I understand some people disagree with, that at least some of the witnesses I saw for the defense were coming across as arrogant and aloof, and therefore would be harming the defense case by demonstrating that kind of attitude. Now, I didn't have to talk to juror number 1 to get that opinion, whether my opinion is correct or wrong. So again, I think there are many explanations for why the wife could come up to that opinion, and one of them being she was there and heard this woman testify and saw the jurors' reactions, other than going home and talking to her husband about it. So then she was engaged on a nearly daily basis talking about the case. And the plaintiff tries to say, well, she wouldn't have needed to watch the case that much if she was talking to her husband. Now, we can all agree that's not the best argument that he's got there, but some of his arguments was very good, or have been very good, I think. Despite this large amount of time talking about the case, defendant cannot produce a single post indicating a discussion with her husband regarding the case. And that's my point. If she had put on there, I don't want to say which juror it is, but one of them is my husband, and he said that this case is going bad for the defense, that would be a problem, right? That's not just having an opinion on the case. That's not being somebody's wife with an opinion. So if his brother said, I talked to my brother, he's on the jury, he said it's terrible. If a friend said, old college roommate, a guy at the bus station said I was talking to the juror and he told me, all those things would indicate a potential actual communication rather than inferring it from the content of the post. So the fact also that his wife is not, I don't think, a legally crux issue, although I understand it's irritating to people who think they're picking on the wife. I do get that, but I'm saying that the wife has no more obligation than a stranger or somebody at the bus or a friend or whatever, that it all is judged by whether there was communication with the juror. And there's not a special rule that we're going to assume that everything your wife does is because you told her about it or vice versa. And they say defense counsel ignores common sense explanations, instead just inferring that this information had to come from the juror. And that's the same for all these things. About the shot clock, I mean, who didn't know about that? If you casually watched a little bit of the case, you knew that they were on a time clock. And if you were from Maya's side, you certainly would have been concerned about that. Let's see. Defendant next argues the wife's posting she was even monitoring the court docket and reviewing the filings. She can do that if she wants to, or she can get it off a YouTube channel. That doesn't really matter. She came to the courtroom. Was she winking at him? Was she sending him signals? Was tugging the ear? Baseball stuff? And nothing happened in the courtroom, at least, to put anybody on any alert. And nothing really happened after that was different than, the alleged social media posting and stuff like that. They have conclusively proven, I think, that the wife was interested in the case. That we can take as a given. That by itself isn't legally significant, in my opinion. De facto agent allegation that this Jules person was a de facto agent of the plaintiff. I mean, that's only to further the alleged connection of the wife to the plaintiff's side and her bias in the case, but I take it as a given that she had developed the opinion that Maya should win. They say that the defendant turned and raised his eyebrows and looked at the gallery there, smiling at Jules. Kowalski puts an affidavit in here saying I was actually looking at Dr. Scott Richards. It's we're definitely at internet level arguments when we're talking about things like this. I'm sorry. You really think that judge is going to go, oh yeah, that happened, so I'm going to throw this verdict out? So I also see here about the name and addresses of the juror, and certainly the address is bad. I mean, I accidentally posted that and took it right back down when I saw it. But the name, they also put their own names out in public, didn't they? Didn't they say that? I mean, this juror's put his name out there. This is my name, and I'm juror number 1. So I'm sure it got more widespread by the fact that it's now in these motions. I don't know that's really a doxing when you go out in public and say, I'm juror number 1, and this is what I have to say about the case. So, let's see here. Entire internet community was made aware of this heavy bias. I don't know about the entire internet community, but then plaintiff switches gears here a little bit and starts saying, let's take a look at what you did on social media, which is also, I think, not particularly legally relevant. That they had their own robust internet activity during the trial with screenshots, receipts, in other words. And Attorney Shapiro saying, I want to thank everyone who's sleuthing this so carefully and meticulously. I've gone through the Reddit thread on juror number 1 with almost 1,000 comments. Everyone on the defense team is monitoring this closely. feel free to keep posting here because we're going to read all of it and put it towards the motion. I agree that the idea the wife knew when the verdict was coming and what they were arguing about is shocking. I hope the judge will feel the same way. But this judge is a real life one. He's not a Reddit judge. And he already gave opinions about juror number 1. And I don't think he's be persuaded by what has been put up. Anything can happen, of course, but I'm just giving you my opinion that it's not going to fly. They also omitted from their motion any active involvement of attorney Shapiro's wife, which why would they put that in motion? Why would they put that in there? I mean, again, none of any of this is relevant unless it shows that the juror is talking to people about the trial. So definitely they wouldn't have put in Shapiro's wife talking about somebody or anybody else. But you know what the plaintiff's doing here, which is what I've seen in a lot of social media contents, is trying to say what's good for the goose is good for the gander. I mean, they had their own people all over the internet talking about things, and you know, everybody's an agent for everybody if we take your position. And there it is. Given defendant's position that the wife's knowledge should be imputed to the husband, Mr. Shapiro is deemed aware of all of his wife's posts during the trial. And by not objecting before the verdict, he's failed to preserve this entire issue. And this is this thing that if the defense had people that they knew or were close to that were alleged agents, then they would have known about his wife's comments, and therefore they should have objected and blah, 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 and all of that. Well, maybe. I don't know that the wife was saying she was the wife of this juror until it was over. I get what he's trying to say, though, which is it's extreme to impute knowledge back and forth, especially to the jurors. Otherwise, you have some issues there, whether you're ever going to settle cases or not, or extreme monk-like existences for jurors, which is also impractical and not warranted by what happened here, I think. Let's see. Cannot be heard. Relief requested in the motion cannot be based on post-verdict statements by juror number 1. Well, that's true. Again, the juror can talk about things about what happened on the case, but again, that's not a blanket that, well, like you got some kind of immunity agreement from the prosecution. If you say you did something terrible during the trial, that could be a problem. But talking about how you thought about it, how you thought about witnesses, and you really don't like these people, you thought the judge was great, all those things that's all fine. I guess you could walk away from a case without ever talking to any member of a juror, and it certainly happens. But lots of times you talk to jurors when it's over and see how they felt about the case, and you know, running around about throwing verdicts out. The evidence, they're saying that any potential bias that the plaintiff had is not the explanation for the verdict. There's plenty of evidence that provides ample basis for the jury to decide against the defendant. And this juror, while I think he ended up being the foreperson, wasn't the only person voting on this verdict, which is part of the insulation you get for the fact that you can't know exactly how everybody's going to behave, is you get multiple opinions coming into votes to deliver this verdict. And here they did that. And then they said, well, here's an example. They had evidence that the defendant deliberately attempted to mislead it in the court. So this is more dunking by the plaintiff here on things I don't think exactly necessary for this motion. And then they talk about the defense saying we need to do this for the integrity of the judicial process. And then the plaintiff uses that as the camel's nose under the tent to walk right in here and rip a new one on the defense counsel, talking about defense counsel's conduct, disrespect towards the court rulings, and it was all palpable. Well, it was to me, I can tell you that. I mean, I've not talked to a judge like I heard these people talking to this judge, and then they talk about the exchange that we know about there, kind of accusing the judge of, let's see, what did they accuse? It doesn't sound like, Judge, you're prepared to listen to the whole matter. I think they even said something worse than that, but I just remember the context of it because the court was like, whoa, time out. That's a very serious statement you made. And are you saying that I'm closed-minded in this case? And they kind of do say that anyway. And they also say that they claim that Shapiro made vulgar remarks while exiting the courtroom, loud enough for everybody to hear, that it was effing ridiculous and effing scumbag family. Did he do that or not? I don't know. Is that relevant to whether juror number 1 and his wife talked about the case? I mean, look at the level of stuff that's not really relevant to this motion, both in the defense motion and in the plaintiff's response. Now, I don't blame the plaintiff for dunking where possible, just like if you're the defense, I don't blame them for trying to show as much smoke as possible so that there would be a belief that there's a fire in there somewhere. And then they also post up another dunk here from the defense team. They say, claiming that you never know what 6 people from the bus stop can do. And did the guy say that? And if he says that, does that represent a disconnect between where this person feels like they are in life and the kind of people who serve on a jury? Because one thing you need to be able to do if you're a trial attorney, and I'm not saying this person was on a trial, is if you're not sincere, you need to be able to fake sincerity, because you don't want to create the perception to the people sitting on the jury that you think you're coming from above and talking down to them, even if you think you're above them and that you should be talking down to them. You do not want to do that. And I'm not saying this about the attorneys necessarily, although sometimes I thought they kind of went all in and being as aggressive as they did in some counts, that if the jury thinks Maya wasn't faking it, they're really going to rip you a new one. And of course that did happen. And I thought some of the witnesses kind of had the same attitude. Now, wasn't trying the case for the defense, so I'm not saying they wouldn't have got a $500 million verdict if I were defending them. It's nothing like being a Monday morning quarterback. But I am saying that how the jury is going to perceive your attitude and the attitude of your witnesses is an important part of the case. It's one of the reasons why you dress like you dress, you talk like you talk, you prepare your witnesses and things like this, because it's not just a cold recitation of facts that decides the case. Everybody's human beings, and you want to create a narrative that's supported by the facts that people go, yeah, I trust this guy. I trust what he's saying. And the evidence he's giving me supports that. And that's harder to do if you think somebody is coming at you rather than trying to bring you with them. That's my opinion. 3 rounds of individual questioning. Well, sure, yeah, you're going to voir dire the jurors, and I'm certain that they did that, because there's also this final allegation here about prior involvement with DCF by juror number 1. And I'm not really going to go into that other than to say, if it was an ancient thing 20 years ago, the plaintiff says that's not really anything that can be possibly material here. There's no evidence that it mattered in this case. And Judge, if you really want us to deal with this, then we ask for an extension to more fully develop it, because there were an additional allegation filed by the defense against juror number 1 that he was prejudiced against the defense because he'd had an interaction with some kind of child issue a long time ago. And I'm not going to really delve into that. It wasn't in what they originally did. And I think also it's just more evidence that, as people have said, now they're launching into this extreme investigation of this juror to see what they can get on him. But in my opinion, perfection was not achieved in this situation by how it was handled by, say, the juror's wife, because obviously I'm sure she didn't want to create an issue for this case. And now she's the central figure in this motion. And she has the right to do, I think, all the things that she did do, whether all that's always wise to do, kind of like the attorney's wife talking about things. Or it could be the attorney's husband or whatever, or friend or whatever. It all depends, right? Everything just depends, but that doesn't mean that it's wrong or reversible. And I think the judge is going to deny this motion. I think it's just all inferences that aren't the only conclusions you can draw from the facts that they state, the posts that they state. And you would have to go ahead and conclude that the juror is a big fat liar, because there's no confession here or admission by the juror that he talked to his wife, or the wife stating, I did talk to my husband while the trial was in progress, and no admission of this, and no direct evidence that information was passed back and forth. And with the judge having already staked out a position that this juror was doing a good job, what are the odds of this motion succeeding? So if I were betting, which I don't, I would bet that this motion gets denied. Yeah. So, I mean, a bus stop comment it is a little bit random, because you get whoever comes on the jury pool, and lawyers, especially litigators, have a level of arrogance, and they need to, and they kind of should, because they're going into a competition, right, where they try to win. So there's always going to be an element of that. And I guess, when I went in-house as general counsel, that's when I stopped doing trials for the most part, and I did some litigation later on, still do it sometimes. But when I was young, because I still have that impression, and this is a long time ago, standing up in front of the jury for the first time, and then the times after that, and looking at these people from the community and how seriously they were taking this, they're pulled out of their lives to put their full attention on what you're doing. They're not really paid for it. To see them trying to do the best they can for that, and took a little bit of the arrogance out of me and made me humble to this process and appreciate that they were there. And, maybe the lawyer has a higher raw intelligence than some of the jurors or something. That doesn't make him more wise. It doesn't make him a better person. And I'm not saying that comment means that this person just looks down on all jurors, because they also could mean you're just getting random people on a jury pool. Could be what he means, but again, it's the context of the trial. I think they did come across as scolding a little more than they should have. That's my opinion. And the legal standard comment says is not if a juror can deny or sufficiently hide personal prejudice, it's assumed not to exist. And that's true. There's this presumption that the jurors kind of following their oath. But in fact, the judge had already passed on this issue to some degree, because they did ask for this juror to be removed. So in fact, the judge did actually look at it. So now they're going to have to overcome what the judge has already decided about this juror. And that's why they're throwing so hard about this whole wife thing, which I just don't think it makes it. So then that means they've got other motions. I'm sure if they haven't already filed it, they're probably going to want to remit the damages amount. There'll be lots of, alleged errors and stuff like that as they prepare for appeal, which they would want to win. And also if they do want to ever settle, which is how almost every case ultimately resolves, you want as much leverage as you can get. So you want as many issues for appeal as you can possibly develop. So you create more incentive for the plaintiff to discount on the award. So anyway, that's the read through on this. I give my opinion. I don't think this one wins it. Yeah, there's only so much you should be doing to jurors, and some of it is on the lawyer to look up things in the front hand. But anyway, we all agree, I think, that if a juror does engage in patent misconduct, this agrees to take money to give a verdict, doesn't care what the judge says, and goes to a restaurant and asks people, "Tell me what you think. That's how I'll vote." There are instances where there is a kind of a communication between jurors, that juror and an outside person, that should disqualify the juror and could result in a compromised verdict. But I don't think this one meets that. That's my opinion. And thanks everybody for stopping by. Talk to you later. Let's see if I can make the magic happen. Bye.